television cameras.
And 2 still cameras.
And 2 still cameras.
That's correct.
And we have the gentleman coming out back from Sac County that wanted to streamline this or something like that.
Yes, sir. He demonstrated his equipment for you right here.
I'm sorry?
He had demonstrated his equipment for you.
Right. Is that gentleman in the back there? Okay. A couple of things for the folks with the cameras up here. Now, it's fine that you're here up front today, but we're going to be doing jury selection tomorrow. You have to be in the back of the court. Okay. Any problem with that? Clear? All right. Very good. Any concerns that the council have in regard to any of this?
Your Honor, the media probably knows this, just so it's clear that when the jurors are here tomorrow, that the media does not at any time film any of the jurors.
That's right. Is there an intention to actually film during a jury selection? No. Okay, very good. All right. Okay, and then
Judge, I would agree with that.
Pardon me?
Obviously, I would agree with that.
You bet. Yeah, I trust you understand that at no time are any of the juror members to be filmed in any way.
Yes, sir.
Any other concerns?
No, that has to be done. No, Your Honor.
Okay. All right, the next thing I want to talk about is the juror questionnaire. This is the first time in all my years. In the last week, I've received 2 requests for juror questionnaires. I've never had that happen before. And I think that actually, I think they're really pretty good idea, except for the timing. That's a problem. Last week I tried another case and got the jury questionnaire with the jury panel was right there, and I thought, wow, this will cause jury selection to actually increase by about a day and a half. What is your, Mr. Powers, is this your deal?
Please, Your Honor. We have used it, I've used it maybe a dozen times, and I know that Mr. Hammond has used it too, but
Actually, the story, it was on the change of venue story.
yes. And myself, I think it expedites the matters, and it also, most importantly, avoids embarrassment.
I think, and I agree with you on both parts. My problem is this, I wish I would have had about 3 weeks ago. So we could have sent it out to the jury pool, have them fill it out, get it back in, and then give it to you to look over. Excuse me, not, what would be your proposal now? Give it to them when they show up here tomorrow?
I don't think I recall ever doing it any other way, Your Honor, as much as counties in which I had practice.
But tell me, how have you done it?
Well, jury comes in, they're sworn, they're delivered a copy of the SJQ, as we refer to it. They then retire with the court's admonition to be done privately, and they should consider themselves under oath. They turn them back in. Then copies are made for court and counsel. 1 copy for each table, 1 juror, and 1 for the court. Then, I think generally, Judge, the jury is dismissed for whatever amount of time the court deems appropriate while counsel goes through them. When they are returned, by then counsel will have reviewed those. Certainly will not request in-camera hearings with each particular juror, only when there is something that is of particular interest or otherwise could cause some embarrassment. The government has their chosen jurors that they want to interview. The prosecutor or the defense has their chosen jurors that are summoned individually to chambers. Their question dismissed, and they're done in sequential order. When that is concluded, then the four-tier process, with which we're all familiar with, proceeds.
Okay. My experience has always been that when you have a jury pool sitting in, we're going to have probably close to 100 people in this courtroom on a jury pool. My experience has been that the dissatisfaction with the jury pool is when they're sitting around doing nothing, or even the ability not to watch something that's going on. And I guess my concern is we're going to have a lot of dissatisfaction among jury panel members if we're giving this to them, setting them up, bringing them in, sending them back out, etc. What's the state position on this?
Your Honor, the state would resist the standard jury questionnaire being used for the reason the court indicated. My experience is when they fill out the day they show up, it actually takes more time than it would if we just would start selecting the jurors. My experience where they have some effectiveness is they have been sent out in other cases that I've worked out with Mr. Powers, but other cases where they have been sent out ahead of time. We receive, parties had an opportunity to review them ahead of time. I think by coming in, filling these out, and doing it this way, jury selection is going to at least take almost 2 days. I believe if we don't use them, we can accomplish what we need to accomplish, still get a jury pick in 1 day. So I guess the state, and also there's some questions in the questionnaire the state would object to, but using the questionnaire as itself at this point in time, the state believes that it would not save any time. We can get out the same information from the jurors that are here. And the other thing to point out to the court is this case has been moved for a change of venue. This is sometimes used where the change of venue has been denied, and there's concern that people in the community have talked about it, even though it's not in the media, and they're concerned they already formed an opinion. I think because this case has already been moved on a change of venue, that shouldn't be as big of an issue.
Okay. Well, I tend to agree with Mr. Cameron's position. Mr. Bass, do you want to say anything else?
Yes, Judge, just briefly, the only issue I would raise is, and I apologize for not having the court 3 weeks ago because that would have expedited this process. The SJQs were provided to the state last week in an email. That request was denied at that time. In reviewing at least the questionnaires, there are issues that I believe should be more fully fleshed out with the SJQ, and the intent on doing it was to expedite the process by avoiding any kind of embarrassment to the jurors and having a better idea of who can actually be fair and impartial prior to selecting the jury. Because I know everyone here wants a fair jury.
Well, I would think that if, as far as you want to say something else?
If the court please.
Sure.
The government's counsel point is well taken, Your Honor, as much as it would have been proper. I don't have a recollection of using an SJQ with a panel of around 100 people. I think maybe you're at 87, I'm not sure.
Somewhere around there, okay.
I don't have a personal recollection of ever going beyond a day and a half, as much as the state's attorney concedes that 4 years would take a day anyway. If we spend another 3 court hours making sure that Ms. Richter's rights are preserved to the ultimate, I think that's time well spent.
Anything else you want to say?
No, Your Honor.
Well, it would seem to me that you can frame your court hour in a manner that if issues do come up that you feel might be personally embarrassing to juror members, you take them back to the chamber. We do that in all special cases.
Right.
I guess I'm old school and I'm leaning towards the way I used to, and I think I'm going to support the state on this. We're going to get the jury questionnaire. We'll start with jury selection tomorrow morning. Okay. Now, we have various other motions that we need to attend to, but we have 4 motions in limine, and I think 1 motion to exclude. That's correct. Okay. Now, I'd like to take up the motions in limine. From the standpoint of the media, I'm going to ask, from a professional standpoint, these are motions that are talking about evidence that will likely not be allowed to come into the record. Because in most of the cases, both sides are agreeing that there are issues that are prejudicial, that should not be presented to the jury. I'm going to ask from a professional standpoint to not broadcast this stuff, at least before we have a jury selected, because if you do, we're probably going to have an awful time selecting the jury. So please bear that in mind. Okay, we're trying to be as vague as we can. I don't care if you film it, if you just be so kind as to keep it off the airwaves until after we have a jury selection. Okay. All right.
Yes, sir.
We have one more motion. Motion to exclude witnesses.
5 different notices of minutes and testimony and witnesses on October 14, 2011, the day that this court granted our motion to compel discovery. The government filed 20 new witnesses. With that, they identified a Reliance telephone systems, Yahoo, Google.
Most of these witnesses are foundation purposes, correct?
Correct.
From a realistic standpoint, do you even need those foundation witnesses?
Judge, I don't think so. I mean, all I know is...
I mean, you're going to check on the foundation. So,
I think I will, Judge.
well, okay, go ahead.
And I understand under the rules of criminal procedure 2.48 that they can amend their witnesses up to and including the time of trial. But the problem with, and the reason why the motion to exclude was filed was this: what the state's intent there was to either force my client to waive her right to take discovery of these witnesses or waive her Fifth Amendment or her right to speedy trial. And that's the basis for the objection for all of these witnesses.
Dave?
Your Honor, state's recollection of the rules are actually, they don't have a right to depose foundational witnesses. And the state's recollection of the rule is as long as we have 10 days prior to trial that we can do that. And I believe that the dates are correct. This was done on October 14th. Trial started tomorrow, which I think is the 25th. So it would be within the 10-day notice as well.
And with all due respect, I believe that we do have the defendant has a right to depose foundational witnesses, but the government then can object to it. So we do have a right to depose those people. But quite frankly, when I'm looking at Google, Yahoo, Gmail, GoDaddy.com, I think I said AOL, Channel 4 News, there's no way that we could realistically depose all of those people in a timely manner 11 days before trial.
You've seen that whatever deposition that I've taken from the brief federal trust at any rate. The reading the case law that I have, it is only prejudicial if I don't grant your motion for continuance. And in the past, defense has indicated they do not want a continuance trial immediately.
Correct.
My position is this. Well, we're trying to work it out. If you're going to be calling foundational witnesses, we'll prevent, take depositions in the evening, because the evenings are going to be full on anyway. During the course of the trial, we can even maybe take breaks, for a short period of time for deposition. Otherwise, if you want to continue in order to take these depositions, I give you a brief, continuance for a couple weeks, or we can proceed as far as prejudice is concerned, without any further review over your motion. What's your pleasure now?
Just a second. Judge, may I have 2 or 3 minutes to confer with my client before I respond to the court's question?
I know when to
If that's all right.
Before we do that, I mean, if you have an issue that you may want to talk to your client about, same type of issue. On that standard jury questionnaire, the defense listed witnesses for the jurors to go through. That's different than the defense witness list that we received. There was 4 people that we have not had notice of. One would be Dr. David Grove, Heidi Collins, Ray Friedman, and Aaron Smith. We're not asking for a continuance, but we have not had an opportunity to depose those. I guess what we're asking, unless the defense needs time and they're going to waive their speedy trial, we would ask that at least the defense provide us at least a summary, which is a short summary of what those 4 witnesses would be around.
Well, Well, Judge, I guess I would disagree with Mr. Hammerhand's allegation there. We have put them on notice of our witnesses. I've sent emails to them indicating that Dr. Grove will testify. Heidi Collins, we've identified. Ray Friedman, we've identified, and that's their witness as well. I think they're asking for Heidi Collins. And what was the last one, Mr. Hammerhand? Oh, Darren Smith. We put them on notice that we intend to call those witnesses.
Well, let's put it this way. If you're going to be required to take depositions in the evening, they can take depositions of those witnesses in the evening.
And I received a reference from Mr. Smith 10 days ago saying, hey, when can we depose the defendant's witnesses? I indicated that the time had passed pursuant to the rules of criminal procedure, but I said as a professional courtesy to Mr. Smith, we would let you depose those people last week from any time from Monday to Friday. And in speaking with Mr. Hammerhand, my understanding was they agreed to waive deposing the defendant's witnesses. Unless I misunderstood his conversation with me, that is what I was told.
I was referring to, and I apologize, Your Honor, the September 7th, 2011 is our notice of their witnesses. I would have liked to have had a chance to talk to their doctor. And there may have been emails, I can't say there wasn't, but I'm just saying, if we want to,
we'll just get along here. And you designate the witnesses that you really do want to depose.
okay.
And you designate the witnesses that you want to depose and work that in. About that.
That'd be fine.
Okay, you want to talk your time?
I do for just a minute, Judge.
Very good.
And then we have one more issue, I believe, is this sequential list of witnesses that the government is going to file.
Give it again.
We filed a motion requesting that the government give us, since they've identified 70 different witnesses, we're requesting a list of their witnesses in sequential order so we can adequately prepare for the people who will
I
be
haven't
testifying.
seen that motion, but has state received.
And if I'm not aware of your honor. If it's in my office, I haven't been there,
So
so.
how about this? You've got all this afternoon to work on it and provide them. In fact, I'd like to have a copy as well. I don't need that.
Your Honor.
I'm sure I did put a copy.
If the state is required to provide that, which the rules don't provide, but if we are, then we think in fairness, the defense has to give us a sequential list beside the defendant of their witnesses at this time as well.
And I don't have any problem with that, Judge.
Okay, in fact, I would like that as well.
Okay.
Now, obviously,
Also, I would like, if I may, since we have a number of attorneys at the table, if you designate as well on the witnesses who will be doing the direct and who will be doing the cross-examination, that would help.
Okay.
All right. Okay, take a couple minutes. We'll be in adjournment for about 10 to 15 minutes.
you're asking that I do that we haven't discussed involving this criminal matter?
No, sir.
I don't have any further questions.
Very good. All right. Do we need to discuss anything else about that motion?
Not on that motion, Your Honor.
Okay, was there anything else you want to discuss?
Your Honor, I didn't know if this was discussed previously about jury selection for tomorrow. The state's understanding is the jurors we call in here
Yes.
will have 32.
Actually, it's going to talk about 34, 35, so it's alternates.
The state was going to request that we have the alternate selected at the end.
Well, let me tell you how I normally do this, and you see if you disagree. We would call it the name, let's say we use 3 alternates. We'd call the names of 35 individuals. Each get 10 strikes in this case. You'll take your 10 strikes and will leave us with 15. When the trial is concluded, I will draw 3 names out of the hat. They will get the alternates. We dismiss them with jury deliberation. The reason why I like to do it that way is we signify to some of these juries that they are alternates from the get-go. I found that they pay less attention. And I think that if they all think they're jurors, they're more likely to pay, it was 100% of their attention, and that's that. Is that disagreeable with them?
It is, Your Honor.
All right.
And I can explain why for the state. First, and I understand what the court's doing and the intention is to have the alternates pay attention, and that makes sense. The concern is, first of all, the rule allows us to have the alternate selected at the end, and we get an additional strike for the alternate. court's way, we lose that strike. The second thing is strategically, by doing it that way, we have 10 strikes. But if we know who the alternates are, which we believe pursuant to the rule we're allowed to know, if we know who they are, we may not use a strike thinking we're not going to get to the alternate, and that gives us that strike to use what we mean. So for strategic reasons, the way the rule is, the state would prefer that we do 32 initially, we each get a 10 strike. We bring up 5 jurors at the end, each get 1 strike, and then we have 3 alternates.
Do it again, the last part, what we're saying.
If we do the 32 first,
Right.
do the 10 strikes, we'll have 12.
Right.
Then pursuant to the rule, we bring 5 jurors up, alternates, we sit them up here, and we ask them questions, and then we each get 1 strike pursuant to the rule. There would be 3 alternates left. Now, we understand there may be alternates. That is a concern for the court. But for the other reason, that's why the state prefers the rule preferred states versus drawing a line at it. Your thoughts on that?
Judge, the court previously told us that we should just get along. I agree with Mr. Cameron's analysis on that.
Yeah, get along with you.
I intend to, Judge.
That's fine. We'll do it that way. Okay. All right. Now, I want to ask, how long do you expect this trial to last?
Your Honor, the state will finish its case. If we get a jury pick tomorrow, which we anticipate doing, we will finish our case Friday afternoon.
Okay.
And the one question I do want to ask the court, a couple things is, if we get the jury pick and it's 3:30 tomorrow, if we get that lucky, or even close to 4, does the court prefer just to wait to do openings?
I prefer to do openings the next day.
Okay. And then the second thing for getting witnesses, scheduling, I
Just
presume.
wait, Frank, even if we get done earlier than 3:30.
Okay.
I doubt if we will, but if we do, I just assume give them that admission, send them home, start out fresh the next morning early, and go to opening statements and go from there. That makes sense?
Sure.
Okay. What about the defense? How long do you think on this case?
Judge, I anticipate we'll probably go 2-3 days.
Okay, we're looking about a week and a half or so.
I think probably safe by getting all the witnesses and all that to 2 weeks, but I don't think it should be any more than that.
Okay, very good. All right, the other thing I want to say is this. I believe in starting promptly on time. Okay, we're going to start tomorrow with the jury selection at 9 o'clock. Not 9:01, not 9:05, but 9 o'clock. So if there are things you need to bring to my attention, why don't we plan on being here at the council here by 8 o'clock tomorrow morning? If there's something else that needs to be addressed, we'll address it at that time. And otherwise, we'll start at jury selection. Okay?
Your Honor, how long does the court give for its meeting break?
1 hour. And we'll take a mid-morning recess about 15 minutes, and mid-afternoon recess about 15 minutes. And as far as quitting time, around 4:30 in the afternoon, if we have a witness that you want to get done with, we could go longer than 4:30. If we finish a little ahead of time, before we start another witness, we may just quit early. Okay? Anything else?
Yes, Your Honor. Discovery.
I'm sorry?
So we still have some discovery issues, Your Honor.
Tell me.
Okay, the yellow post-it notes, we received a letter over the weekend from Sheriff McClure indicating that they can't find them, and that now they're saying that they no longer exist. However, numerous witnesses have confirmed the existence of these post-it notes and the fact that they were given to law enforcement. So that's an issue. There's also the existence of 7 pages that were, and I don't have any idea what are on these pages, Your Honor, but they were turned over to law enforcement at the same time and will be the state accepting those do not exist. We did receive the...
Where potentially those, you post notes first, and what was the second one?
It's 7, I believe, yellow sheets of paper. I don't know what's on those sheets of paper, Your Honor. But they were turned over at the same time to law enforcement after a search was done at Dustin Beatty's room.
The ladies' room.
Yes, Your Honor.
Okay.
We've also requested information on the contents of Dustin's computer hard drive. The state did provide us a text file of the contents of the hard drive, and literally, Your Honor, it's hundreds of pages, but there doesn't appear to be any actual substance. I mean, it indicates that there's JPEGs and such pictures, but as you can see, there's obviously no pictures that were provided. So we don't
And
actually...
whose hard drive was this?
Yes, Dustin Beatty's, Your Honor. They did provide an additional additional, I think, 3 or 4 pages of actual documents that I believe came from the hard drive. But obviously, when I have a picture, this thing actually I just hit the stop hanging after so long, Your Honor. There was more on that computer than just a few pages, and this does not provide that information.
What about providing a hard drive to defense?
Your Honor, that opportunity was given to the defense from the outset of this. We had no intention of going back through and trying to hook that up against a 10-year-old computer and to make copies or digital copies for whatever information is looking for in there. But I don't have any problem giving that over to the defense if they want to get a copy of the hard drive.
We would prefer a copy of our drive versus, so we have to lease it.
Is the hard drive going to be used in any evidence or anything?
Not for the state.
Okay. But how about a copy? Would a copy suffice?
A copy would, Your Honor, that's what we received, obviously didn't allow us to examine the content of the hard
Take
drive.
care of that. That's done. All right. That should be given. You have that. When can you make that available?
Your Honor, I can have the sheriff. That's been up to him in his schedule because it's in his evidence locker.
The sheriff has it.
The sheriff does have it, Your Honor.
Okay, why don't you talk to the
Oh,
sheriff?
excuse me. I apologize, Your Honor. It is here.
Got it?
Yep, we do have it.
All right. We got to make a copy.
Yeah, I can call some technical people and see if I can get a copy of it.
Oh, yes, it would be. And then the 7 yellow sheets of paper, what do you know about that?
Your Honor, it's my understanding that the sheriff's office has gone through their records and information that they cannot locate and show 7 yellow sheets of paper, is what I've been told. And it's my understanding they also searched for the 2 yellow post-its, and they cannot locate those either.
Your Honor, and I believe the letter that was provided to the defense counsel, the letter that was penned by Sac County Sheriff Tim McClure, he kind of reverse engineered the post-it note discussion and came to the conclusion that if they did exist, which they may very well have, that they were never taken into evidence or they didn't contain any sort of significant information. I guess
There are instances of witness statements, Your Honor, both Robert Hatchett, Mona Meading, and I believe Lieutenant Assessor Officer
witnesses will be permitted to testify in that regard. We can't find them, we can't find them, we can certainly testify to the items as well as what was on the items. Okay. Anything else?
Response number, Your Honor. The state has also indicated that they do not have any phone, cellular tower records for Michael Roberts or Mona Weedy. However, again, in the law enforcement investigation, they make reference that they have prepared these records, that they have verified Michael Roberts' alibi with these records, and the state provided us a long-distance bill for Mona Weedy. So that is it, Your Honor. Clearly, based on the investigation reports, there are other records out there that
Phone records? And
Yes, Your Honor, the phone records again, the evidence in this case obviously is voluminous. It does, and I do agree that at some point in time, it does appear, at least from the investigative reports, that there were phone records obtained, whether they be, facsimile or whether this be pursuant to some conversation with the phone company. And I have no idea whether they ever existed in hard copy form or, whether they still exist. They would have been provided to the defense counsel. I haven't seen anything other than the actual phone records for the business / home of the Roberts, which has been provided, and then the Weedy real estate records, which I guess was under the assumption that Mona Weedy's deposition was being put forth as her cell phone records.
No, we have, Your Honor, a long-distance bill for 1 month period for Mona Weedy. So all we have is a long-distance call to
and you have information that those records were obtained by law enforcement during their investigation.
Yes, Your Honor, law enforcement indicated they obtained the tower records to confirm Michael Roberts' whereabouts at the time of the shooting.
Is there any manner of obtaining those records from the phone companies at this time?
We have tried, Your Honor. One of the phone companies is out of business. We have been unable to get, we have tried to get them on our own, Your Honor. We've been unable to.
And the state has come through your, whatever you got and find it.
Your Honor, the state has gone through everything multiple times, and believe me, I think it would benefit the state just as much as the defendant to have these records. Again, the investigative reports are not, they're not exact as to whether these things are hard copies, whether this verification was made by some phone conference with the phone company. It's just the investigator's narrative that they, have reviewed phone records. I guess you can assume that there are copies, but everything that the state has, to the best of its knowledge, has been provided to the defense counsel.
I don't know what I can do to help you out in this regard. What's your suggestion?
Well, Your Honor, I do have a suggestion, at least in part. Law enforcement has made reference that they did receive the cell and tower records confirming Michael Roberts' whereabouts. I would propose that they not be able to state that, for one, because we can't confirm that information, and the state doesn't have that information for our either.
If they don't have the records, they're not going to be able to refer to not against the records to confirm his whereabouts.
Right, but they may also say,
I'm sorry?
they may also just have the question, did you check Michael Roberts? Oh, yeah, we checked the tower records, he was where he said he was. So I would really not be allowed to do that.
I think you should be able to see the records in order to confirm that. Okay. Yes.
It's state here, Your Honor.
All right.
And as far as the lack of records on Mona Weedy's, I'm not sure what the proper remedy is for that, Your Honor, but it's directly relevant because we believe it shows an inconsistency in her statements, indicating that she didn't have further conversations with Mr. Collins when they had prior to saying that she did. We can't confirm what
Where you
happened.
prior?
Mona Weedy, at one point she indicated she never talked
Do
to
you
him.
have that on record in some regard that you made those statements?
Yes.
Definition.
One is in law enforcement interview, and then we have some reference to it in depositions.
All right. Can you do that through impeachment?
Well, I hope so, Your Honor, but we won't have the records, obviously, to.
But you do have conflicting statements.
We do, Your Honor.
that sufficient?
The only issue I have with that, I don't know the remedy for this, Your Honor.
I don't either.
It's because of the conversations between, there is a reference that Jeremy Collins' name was up on the caller ID as the last person to contact the Weedy residents. I don't know the link for that phone call or anything of that nature. And that is really...
Is that a company that's out of business now?
I don't recall, we did this at the start, I just have to get their, so records, and I can't recall specifically, what we did, but we did attempt to subpoena records and such, Your Honor. I don't know how to remedy that, Your Honor.
Judge, the reason why that's relevant is Mr. Collins, the evidence is he was the last person to call the Weedy residents prior to Dustin Weedy's death. Clearly, those records would be very relevant if it was a 30-second conversation or if it was a several-minute conversation as far as establishing whether there was a connection between Mr. Dustin Weedy and Mr. Jeremy Collins. So that is hugely prejudicial for us to be unable to have that. And there's clear evidence that those records were subpoenaed by law enforcement shortly after the shooting, and we don't know where they went. And we have asked for them a number of times. It's not like we're just bringing this to the court and making it the court's problem.
Your Honor, I mean, they're exactly right. You've asked them a number of times that they aren't unable to obtain them by a subpoena in the state's not. I guess the state's just confused as to what cell phones were, one of Weedy's were referenced in her deposition that was taken on September 12th. And I guess I could be mistaken, but weren't there conversations with regards to cell phones, and even one of those cell phone print-offs at least were entered as an exhibit?
That, Your Honor, is the long distance bill that was entered as an exhibit, which is all as far as
Not the
I'm
records.
Right.
Do you know which company it was?
The cell phone company, I'm not sure, Your Honor, but there was Frontier Communications, there was the Cloud USA, MCI.
Okay. Ms. Weedy doesn't inform me what company she was using at the time?
I believe she was using Frontier Communications, Your Honor, and it could have been Cloud. I know specifically Cloud was out of business. That was.
Do you think if you get a subpoena that you could obtain those records from?
I believe we have
He is the one that did the document, that's the report, the report, which has been provided to the defense. So he is the one that they're referring to.
Okay, what about that?
Mr. Smith provided a response to our most recent request. He directed me to a portion in the discovery file. It didn't contain the report of Mr. Licht. I'm not promising.
Do you have a copy of that report?
I do in my car.
Your Honor, give me 1 second.
Well, fine, if you got it in your car,
Yeah.
provide it today.
Okay. I can get that.
And it may be possible here that we do have it.
All right.
It's just the direct portion of the
Okay.
And Counselor, are you speaking as to the report or, I mean,
I have the impressions. I haven't seen the reports.
What else?
There were some phone cards found on Mr. Reedy. We have scanned images. The state indicates they don't have the originals anymore. I don't know where they have gone. But we have the images, so as long as there's no objection to us using
There
the
will be an
actual.
objection to that.
That's this, you know, we agree.
So there's be no objection to sustain it.
And then also, during our appellate deposition, he indicated that he had photographs that he was going to provide to Mr. Smith. I don't know if those have been provided, but they have not been provided.
Your Honor, Dr. Carroll emailed me yesterday, he's dropping them off in my office today, and I will have my paralegal scan them and then have them emailed to me. But otherwise, the autopsy photographs taken by law enforcement were provided in August. Defense counsel, in a recent inquiry, have asked for the doctor's actual photographs taken. We have a copy of this to you as soon as he gets that to me.
Okay. All right.
I don't object as long as they receive them, Your Honor.
Okay.
And I believe that addresses all of the outstanding discoveries.
All right. So the only one that's left open is in regard to the email. Phone record, yes. Okay.
Your Honor, I did have a question for jury selection.
Yes.
Would the court have any objection if the defense counsel and the state can come up with a different arrangement for the tables?
All right, then we'll do whatever you want.
And then the 32 we can have in front, so it's being.
Yeah, we'll put what we normally do, the gentleman, is put the phone there, we use the front row rather than we use one. We always try to keep those that are selected in the front 2 or 3 rows. Okay, so you're always facing them instead of behind them.
And I don't know if the court has or the courthouse has the appropriate chairs. The other thought is if
We can probably find the chairs.
put the chairs in front here, if we move back for the court reporter, might be easier to hear the chairs.
That'd be fine.
Is that okay?
Fine with me.
Got it.
Oh,
We already have chairs. All you have is the chairs.
Okay, I didn't know if there's any extra chairs. Okay.
And I just want to make sure, Judge, we start with one far back right, and then
yeah, there's one back here,
Yep.
Go right to left.
1 through 6, 7 through 12.
And then you go that way and then back in there.
Yeah,
I don't know what happened.
13 to be over in the corner. Well, unless we put chairs on.
If we find it, I understand.
13's over in the far right.
Yeah, unless we have chairs on.
That's right.
And we can check it just in case there's some extra.
Okay.
Okay.
And I just want to make sure I understand, Mr. Chairman, you're making reference to having the word diary recorded?
I thought the defense wanted that. I don't, doesn't matter, it's taken away, if you're big.
We want to.
Okay. I just assumed that's what they requested.
Anything else?
No, you're right. We can talk.
Are all of you here in town now? folks will be here to swear them in, of course, and I will just give a little cursory conversation as far as thank you for showing up there. And